can be seated. All right, before I rule any further argument, anything you found while I was out looking?
Because the only thing that I would cite the court to is 701 and 702 as far as testimony of experts. Specifically 702. So, again, I would reiterate to the court that he is not qualified to render opinions.
Say that I disregard what he has said that seems to be an opinion. Is there any reason I shouldn't look at the modification that he's done on the video if I disregard that?
Yes, Judge, because he is changing the evidence. He's putting the evidence in a loop, so to speak. They want you to look at evidence that has been placed in a loop that keeps playing like over and over again. He's changing or altering that evidence, Judge.
Isn't that just the same evidence slowed down and put in a loop?
Essentially, Judge, from a person whom is not qualified to do. I mean, no disrespect to him, Judge, but he is no more qualified than Mr. Smith comes off the street and comes in here and says, I have a basic knowledge of computers and how they work. Essentially, Judge, that's what it boils down to.
All right. And before the room is
Yes, I do, Your Honor. He's not doing anything to alter the film itself. All he is doing at this point in time is two things. Number one, he's using a different media player to view. And I think that even in chambers, when we had discussions, one of the questions was, well, what does this play on? What media players will this play on? He chose a particular media player because of the fact that he is able to actually stop certain segments and view those segments in isolation. He's testified that that doesn't change the film itself. It's no different than someone getting a photo and replicating and saying, yep, this photo looks like this photo, which he has the ability to do. You don't need to be a forensic computer specialist in order to do that. We've laid the proper predicate. When I look at Earhart, certainly we've laid the proper predicate according to Earhart. And if anything, they can argue as to the weight of it, but I think when you see both videos, they're going to be identical.
If they're going to be identical, why do I need to see the second?
Because of the fact that he has the ability to actually focus on a very important part for the defense, and that is Mr. Olson throwing that phone at his head. And our video shows exactly that. It not only shows throwing the video at his head, it shows the video bouncing off and hitting the floor.
It shows the video hitting the floor, the phone hitting the floor.
You actually see the light of the video coming towards his head, then going down, and then all the way down to the floor. Absolutely.
And that's my point. Who is going to testify that that light or that flash of light is a phone?
I don't know.
It's circumstantial evidence, just like their presentation of other evidence, Your Honor.
All right, I tell you what, I'll watch it. Here's what my ruling is going to be on why I'm going to watch it. I have a DVD player and a Blu-ray player at home. I don't need Stephen Hawking and Steve Jobs to come to my house and hook up those two things and take a disc from one and put it in the other. I get a better quality video if I look at it in the Blu-ray than I do in the regular video player. It's the same disc, it's just a better machine. If he's saying that he found a better piece of software, there's lots of software out there. It's a function of being young to know that there's lots of software out there that you can load off the internet for $60 and look at stuff. If it's the same if it's the same program and the same file in a different program, it doesn't change it. And I'm not a jury. I'll look at it, and this isn't a jury trial. This is just a bond hearing. You want proof, evident, presumption? Great. He has every chance to confront the evidence and put it in a Blu-ray player instead of a DVD player if he wants.
Judge, may I question Mr. Sacco on one other point then?
Sure.
As far as voir dire goes. Mr. Sacco, you indicated that the type of software you used was the most updated version in order to view this? I think you said it was Media Player Classic.
That's the correct software.
And you're saying that's the most advanced software in 2014 that you could view this on?
No.
Okay.
That wasn't what he was saying. Huh?
Well, I'm asking him that.
No, I don't know that for sure.
Okay. Do you know that the Media Player Classic was released May 29th of 2003?
I need to answer that question.
This is a separate question, Judge.
Overruled, and I don't think you said that either. Did you ultimately watch this on Classic, or did you put it in something else?
Ultimately, it would played in Classic.
We played in Classic, okay.
All right, so are you aware of the fact that Media Player Classic, the initial release was May 29th of 2003, 11 years ago?
That sounds correct.
Okay, is that what you were watching this in?
Yes.
And you're saying that's the most advanced version that you could apply to this?
I'm not saying that.
Okay.
Overruled, and Mr. Escobar, I'm listening to the question and the answer, I promise. I'm listening to all this stuff, all right?
Is there other technology that is far more advanced than Media Player Classic from 2003 in order to view this?
It's very possible.
Well, I'm asking you, you're the one that has all this knowledge about computers.
I'm sure there's other ones out there. This one in particular had a few features that were very helpful in playing this video the
Okay,
way.
you couldn't find any from 2013 or 2014?
It didn't matter to me, the year.
Okay.
That one
So,
worked in-
if I understand you correctly, you're relying upon technology that came out 11 years ago.
It's also been updated and it's,
When was it updated? Tell us.
I don't know that for sure.
Judge, again, I would renew my objections. He's not qualified. He's not qualified to change the videos. He's not qualified to tamper, or whatever you want to call it, Judge. Put it in a loop. He's not qualified to do this, Judge. I think it's misleading the court.
All right, I think,
Judge, if I might, I understand what the court's doing it, and that's fine. The problem is that because we have a lot more to do in this case, and it's bothersome that there's not been reciprocal discovery. We're seeing this for the first time, after the court has said, give them the tape before we even file a charge, give it to them right away. They've done something to this that obviously, I'm going to say done something to it, they've changed it in some fashion or put it in a form for them, and we didn't have any opportunity to look at it. So we're kind of playing catch up on this as to what it is. It may not make a difference in the ultimate decision the court makes, but I think as we go to the future here, we shouldn't be confronted with this kind of stuff.
well, in the future, all the discovery rules are going to be enforced vigorously, so I'm promising that that's not going to be a problem. All right,
If you follow what I'm saying?
I do.
The last 45 minutes, we wouldn't have had to have been spending all this time doing this if they had bothered to tell us something about it in the past. Because we may differ as to what they think it shows, and it may create argument that where we differ, and we would have been able to resolve that perhaps, or at least be prepared for it if they had followed the rules of discovery, like we have.
I'm not finding a discovery violation on either side, and I think both sides thus far have been very generous in the way that they've conducted themselves, and we're going to continue down that road. I'm going to take a look at the video now if that's what you want to play.
I do, Your Honor.
Oh,
Your Honor, if we could turn the lights down,
sure.
if we could, yeah. The first video that I'd like you to play is the full-length segment of that event at the theater number 10, and then we'll take the looped section. And I'm going to be asking you to stop it at frames starting at the second 24. Stop it at each segment. Okay? Let it continue. Okay, you can stop that now. And let's go to the looped. Then may I approach the witness just briefly? Did we try to capture also this area right here, right before the light is shining?
Yes.
And the light that we are talking about is the light that comes here and then finally goes down lower.
Yes.
You can stop it. Your Honor, we would move into evidence.
We'd like to see the other one, the third plate, too.
Can, absolutely. Play the third one. Okay. Your Honor, we would move defense exhibit composite number 6 and 10.
Over the state's objection, I'll admit it. In 7, now a sleeve 4 to the odd 7 mark.
I believe I did, Your Honor.
I'll admit, so that's 6.
That's 6.
You had a solitary video that you were going to mark as
I do.
7. Is that the one right there?
That's the state's version. If you'd like to put it into evidence, we can, just so the court can see that they're one and the same.
That doesn't matter, man.
Okay, we're not going to introduce that.
All right, it won't be so.
We have no further questions, Your Honor.
All right. State, you need a moment to consult?
May it please the court. Mr. Sacco, you would agree with me that from the first loop to the third loop, right before the shot, there's a 14-second delay?
Yes.
Okay. I have no further questions.
Any redirect?
Yep. Mr. Sacco, the downloaded video that you downloaded from the hard drive,
Yes.
is there a 13-second delay?
In the main file, no.
Okay. What does it show on time? Can we play it?
Yes.
Okay, let's play that. That's the government's evidence, correct? Give me,
I don't think he answered the question.
Is that the
I'm sorry?
Is that the evidence that was provided to you by the state attorney's office?
I can play that one. This is the exact same. This would be the one provided by the state attorney's office.
and Nick, what he's talking about, I'm talking about the hard drive one, is that the top one?
Yes.
Okay, that's the one that I want you to play. That's what was provided by the state.
Okay.
The hard copy on the hard drive. There you go. And I want you to count the seconds of lapsing between the cell phone screen light that we captured on the loop and then,
Sustained, I'm not going to consider it characterization of the cell phone screen light. I don't know what it is. There was a light.
A light.
I don't know what it is.
I want you to count from the light to the actual firing of the weapon that you see at 36:37. Light being at 24:25. May have to fast forward it a little bit.
Fast forward to the,
There you go.
It's not playing properly.
So just hit play and let it run.
I don't think it's running is the problem.
If you want to do the other video, the actual disc that state gave you, you can do that as well.
I need
Judge,
that back.
Yeah, if I might, isn't it time stamped? So Mr. Esquire asked him to count out loud?
I think
It is timestamped.
He did ask me to count out loud. It is time stamped, and I've watched it on my Blu-ray player about.
Yeah, so
15 times.
from the time stamp of the loop, the two loops they've shown, there's a 13 or 14 second time stamp between that loop and the third loop, or the first appearance of the light and the second appearance of light. That's what question we asked.
Okay.
Do they disagree with that?
I think he agrees with it.
I agree with that.
Okay,
That's-
so we're all on the same page. We don't agree on that much. Where everybody.
Why are we asking these questions?
Well, because they were insinuating that somehow there was some missing film, and there isn't. That same 13 seconds appears on theirs.
I don't think they were. They were just asking to confirm that there's 13 seconds.
That's
And there
the
is.
wrong view.
Mr. Sacco, that's fine.
Yeah.
Yeah, we don't need to cut that. Just close that. All right. Any other questions you feel compelled to ask?
No, Your Honor.
State and redirect you feel compelled to ask.
No, sir.
Fantastic. Thank you, Mr. Sacco. Your excuse.
Thank you.
Do you wish to call any more rebuttal witnesses?
No, Your Honor.
Okay. State, any rebuttal witnesses?
No, sir.
All right, and we're ready to go into closing arguments on the bond hearing. Before we do that, Mr. Grimaldi, I had a chance to read over the autopsy. I don't know if you had a chance to look at it. I looked at it closely for any personal information that could in any way be necessary to redact. I didn't see anything that jumped out at me. Again, I'm looking at it as a dispassionate third party. Is there anything that you want redacted specifically?
Yes, Your Honor, it was slight, it was just his date, it was just his age.
It's age?
Yeah, as an identifier beyond anything else.
It's not already, state of birth's not already public record? I mean, I'm pretty sure it is, but if you want it, I'll have it redacted and we'll introduce 2 copies.
Judge, the only, if I may, the only other matter on that would be his name, and I understand how, practically speaking, that might be awkward, but under Florida Statute 119, public record victim identification information would be redacted, if you're looking for things to redact.
Okay.
And that's why the age is.
We have a form here, Judge, that we piloted some of the things we suggested on, if you'd like it.
let's do that.
Show it to Mr. Escobar.
Yep.
Those three, 'cause I just didn't think that was.
Okay, it's only 3 pages.
Yeah,
Then I'll remove those.
those are the
May I
only three
approach,
pages we
Judge?
You
got.
may.
Your Honor, can we see the other pages, because we didn't get that in discovery, and that was the first time that I was able to get these other pages.
Is there any lawful reason I shouldn't let them see them? Staple isn't very good listening anyway. You want to staple right now? All right, you okay with the redactions, Mr. Escobar?
I am, Your Honor.
Great.
If I may have just a second.
All right. So this will be the one that's sealed?
Your Honor, we would like the remainder 3-page to make that report complete. It's been redacted as well, and we have no problems with the areas of redaction.
Does the remainder 3 pages in some way,
They've redacted that part. I guess they thought that they'd given me the whole report, and so they went through that portion as well.
okay? All right, that's fine, but I need a second copy of this because I'm going to direct that be sealed, and then I'm going to direct that this redacted be entered as Defense Exhibit 5. 5, right? Or 4? 4. So this will be 4 redacted, so I need a complete copy for 4 to be put redacted, in the original form in the sealed portion of the file. That's Courts 1. So, unless you want to waive sealed portion, or we just only go with redacted.
I think it should only be redacted. There's no reason to seal any of it.
Great, we'll do that then. We return that. That'll be the one that goes in, and we're going to black mark over all the stuff that's highlighted. Okay? So I'll direct you to take a black marker and go over all the stuff that's highlighted. You want your tag. You want me to shred this for you? Or is somebody else going to take care of shredding this?
That's fine, Judge, you can shred it.
I'll shred it. All right. State, before we go into closing, how much time do you need to prepare? 10 minutes? You ready now?
Yes, sir.
10 minutes, or you ready now?
We're ready.
Okay, great, let's do it. Before we go into closings, Mr. Grimaldi, you've talked to your client, she doesn't want to make a statement prior to making the decision on bond.
Correct, Your Honor.
She's going to want to make a decision, a statement after I make the decision on bond. All right. Mr. Escobar, it's your motion, so you're going first. Why should I grant your client bond? If I should grant your client bond, under what conditions would you recommend to the court?
Your Honor, my client has been a lifelong member of Florida, the majority of his life here in the surrounding communities of Pasco County. He has led an exemplary life as a law enforcement officer, and not just a law enforcement officer, but a decorated law enforcement officer, where his primary duties and exclusive duties as a law enforcement officer has been to protect the public in the state of Florida. He's got 2 children, a lovely wife that he's been married to for 46 years. He's had a great career as a law enforcement officer, but also as a great career as a director of security for Bush Entertainment. As you heard there in the audio tapes of predominantly his wife, he has never had a shooting as a law enforcement officer in his entire career. However, as you learned from individuals that came before you, he was selected by the chief of the Tampa Police Department in order to start and develop and train their most selective force, and that being the tactical response team. This is an individual of principles. This is an individual of integrity. He is a church-going man. there is absolutely no reason to believe that Mr. Reeves is a danger to anyone in this community or any other community. As all the witnesses have told you, they likewise don't believe that he is a danger to the community or a risk of flight. He lives in Hernando County with his wife. He owns his home. This is his retirement home. This is where his daughter lives. This is where his granddaughter lives. The ties are incredible. He is an individual that is on retirement. He's an individual that depends upon that retirement, not only for him, but for his wife, and for his daughter, and for his grandchild. He is not an individual that's going to do anything to upset that situation. I'd like to talk a little bit, Your Honor, about what I believe to be an appropriate condition of pretrial release. As the court knows, there is a preference for non-monetary conditions of release in our laws, in our rules of criminal procedure, as well as in 903. And there's a reason for that. Individuals like Mr. Reeves that have absolutely no history whatsoever of criminal activity, and just the opposite, that has a history of being one of the most decorated law enforcement officers that protect the public for 27 years, shouldn't need a monetary bond. And I say that with all due respect to this court, because although the court has to look at the charge, more importantly, the court has to look at the history and the ties that Mr. Reeves has to this community. Do we need a monetary bond? Absolutely not. Has the family and friends decided, hey, if the court feels secure with a monetary bond, are we able to do that? Absolutely. And I think, Your Honor, this family could make a monetary bond of $200,000, which in essence would be his home, his most valued possession at this point in time in retirement, the only home that his wife occupies and his daughter occupies. Does anyone in this community, in any community, think that he is going to forfeit that and flee? Through some of these hearings, I know the court had some concerns that, well, we know how Mr. Reeves was for the last, 30 years or 30-some years. But what tells us about Mr. Reeves today? And we brought individuals before this court that knew Mr. Reeves back then and that know Mr. Reeves today. Individuals that went to that very same Cobb Theater for 25, 30 times. And not once did they witness him being agitated over a cell phone or anything in that theater. Their highlight of a day was, we're going to go to Sonny's Barbecue, we're going to go to the matinee theater at the Cobb, and then we're going to go to Dairy Queen so that we can get some Dairy Queen. It tells you a little bit about who Mr. Reeves is at this point in his life. There's other options for this court. The court could order him in a sort of house arrest, monitor or no monitor, public or private.
Have you already secured a monitor company if I order that?
Your Honor, I know that I have a monitor company that would be more than willing to do that, but I have not been presumptuous enough to go out and select that service without this court hearing this court's order. But there are private, there's Roche bail bonds, which I have worked with on numerous occasions, that I am certain would be more than willing to do a monitored program with Mr. Reeves.
Have you used the monitor in the past?
I have used the monitor in the past.
Okay.
And these are responsible sureties that would answer to this court under any conditions. The court can place restrictions on where he can go. We've told the court already that there are no weapons in Mr. Reeves' home. He is 71 years old. He could live in his home without going anywhere. He's 71 years old.
What assurances would I have that he wouldn't have any weapons after he got out, though?
Your Honor, you could have his assurance and you could have his son's assurance, who is a Tampa police officer with no blemishes on his record, that will tell this court that he will himself make sure that Mr. Reeves has no weapons in his home at any time. And if that means every day, unannounced, coming over and searching his home, that's exactly what his son would do. His son was the first one, Your Honor. His son was the first one at the Cobb Theater that actually held on to Mr. Olson and applied pressure to his chest. Mr. Reeves' son was the first one to do that.
I don't know that because that wasn't something that was testified to, and I'm not going to consider that. I'd like to consider, though, do you have a list of all the firearms that Mr. Reeves owns? And I'm not asking for you to read it out loud in court, but do you have a list of said firearms so that if I were to direct that the sheriff's office were to secure those firearms in their safe evidence room or wherever else they felt appropriate, that they would be able to take control of those weapons prior to him being released?
Yes, Your Honor, his son does have that list.
Okay.
I'd like to talk about the facts of this case because I don't think that the proof is evident and presumption great. The government brought some lay witnesses here before Your Honor, and those lay witnesses were all over the place as far as their testimony. Let's talk about each one of them if we can. We had Charles Cummings that came before Your Honor, and he indicated that he was there at the Cobb Theater, and he was pretty candid that, yes, I've got bad vision without my glasses, and he indicated the one thing that I think was monumental in this particular case. And he said, yes, I looked over, and I saw Mrs. Olson holding Mr. Olson back. He said, that's when I felt maybe I need to do something. Obviously, he didn't have the opportunity. But that's a state witness that's telling this court that he realized that that episode had gotten to the point where he himself felt that he needed to intercede. Clearly, Mrs. Olson, by her own testimony on the recording, says, I had my hand on his chest. And that's where she was shot. While she had that hand on his chest. There was only one shot in this case, Your Honor. For Mrs. Olson to recognize that, hey, I better get up and I better put that hand on my husband. Remember what she said in that video. Men are hotheads. I disagree with that. That may be her assessment at the time of her husband. But Mr. Reeves is no hothead. And there is absolutely not one scintilla of credible evidence that he was ever a hothead in that theater. What did Mr. Reeves do when he tapped on that shoulder and he said, Mr. Olson, turn your cell phone off. They've put the message on the screen. And Mr. Olson looks at him and says, fuck you. Does he take matters into his own hands and goes into combat, or does he pull his weapon and shoot him right then and there? Absolutely not. What he does is he takes the responsible course and he leaves that theater to go advise management. The responsible thing that we would hope that every citizen would do in this great county. And remember, I believe it was Mr. Cummings that said, well, he was mumbling as he was going down the aisle, and he hit my back of my seat. Did you see on the video Mr. Reeves having to hold on as he's walking down the aisle? Even Mr. Cummings admitted, yes, tight space there. The mumbling that he was talking about was what Mr. Turner was saying, that when Mr. Reeves returned, he said, excuse me, sir, I'm trying to get by. Is that the attitude of
None.
It was testified to that a phone was found at his feet. I'll take that as my recollection. Was found at the base of one of the chairs, and one of your witnesses, Corporal Hamilton, testified that there was a phone at his feet.
Because I just want to make perfectly clear that there's no evidence that a phone was thrown in that video, and I think that Mr. Escobar has alluded to that.
He's drawing inferences from what he saw, and he can feel free to draw whatever inferences he chooses. You can draw whatever inferences you choose, and I will make the ultimate conclusion as to what I think I saw, if I saw anything. Okay?
Yes, sir.
All right.
And that inference is so strong for the following reason. We're going to go back to now Mr. Cummings. Because what does Mr. Cummings say about that cell phone? Remember what he said? Well, you could see the bright light of the cell phone. As Mr. Olson was holding it, he was holding it in his hand. You could see the bright light there of the phone. That same bright light you see flying at Mr. Reeves, coming down and landing on the floor. But Mr. Proctor wasn't concerned about that. Mr. Proctor doesn't know the weight of an iPhone, doesn't know the size of the iPhone, but the damage that an iPhone can cause by a 6'4", 200-plus gentleman flinging that phone at someone's head is incredible. But the phone wasn't that important that night or that day. But it sure was there at the scene the minute that Mr. Hamilton came, saw Mr. Reeves, and there it was. So this is not a throwing popcorn case only. This is throwing a deadly missile case. The speed of a phone by a 6'4" human being is pretty daunting. And especially at a 71-year-old man who has arthritis in both hands, arthritis in the bad back, and all the ailments that we've depicted in our motion.
If he was struck in the head with the cell phone the way you're describing, though, shouldn't there have been a mark on it?
Maybe, maybe not. Because we don't know. My phone has a rubber...
Judge, I'm going to object as to the relevancy of his phone, Judge. Number one, how is it relevant? Number two, is he going to testify in this case? Is the court going to place him on the road as to his phone having a cover on it or whatever? He's arguing facts, not in evidence.
He's arguing common knowledge. I've got a cell phone and I've got a cover on it. He's arguing just common knowledge at this point. It's not, and there's not a jury here. So I want to hear his arguments. I'm going to want to hear your arguments, and so tell me.
And Your Honor, phones have covers. Some covers are soft. The point here is, shouldn't Detective Proctor have been the one, he's the lead homicide detective in this case, to really analyze that phone and to tie it together, not 24 days from the incident, but that day, before he's put in handcuffs, before he's taken to the Pasco County Jail. And yes, I believe that certainly, if you throw this, you can have both visible injuries or not visible injuries. But what comes even after that first light comes at Mr. Reeves' person? What happens after? Does it stop? Is his assessment that he told Mr. Proctor, Mr. Proctor, I was scared to death. I could see this large man. I could see his facial expression. I could see his aggression. I could see, that was his words, I could see it wasn't going to stop. Did it stop? Did it stop? It didn't stop. In fact, just the opposite. We see on their video, Mr. Olson going right up to, and again coming at my client. Now let's think about aggression and the escalating pattern of someone in a theater, because that's the way we have to assess the factors. You remember, decorated Deputy Chief DePaulus, second in command, all those years in the Tampa Police Department, was also the co-founder of the tactical squad. And he said, we have to take all these factors into consideration, and we have to make a decision that quickly. And he was doing what he was trained to do for 27 years. Mr. Garcia is not trained to do that. I'm not trained to do that. Mr. Michaels is not trained to do that. But I can tell you by the evidence in this case that Captain Reeves was very qualified in making that assessment. And he was in the best position to make that determination whether at that point 3 things were happening. Number 1, he was going to be seriously injured. Number 2, a forcible felony was going to be committed against him. And we're going to talk about forcible felony in the state of the law with that. 3, any felony. We're going to talk about any felony being number 3. And let's take that right now when we get the opportunity. I outlined for the court the law concerning the use in self-defense of justifiable deadly force. And let me read to the court 782.02, which is found in the homicide section of our statutes. And it says, the use of deadly force is justifiable when a person is resisting any attempt to murder such person, or, this is the big one, to commit any felony upon him. Now, it's not part of the stand your ground options, and there would be a duty to retreat under 782.02. But it doesn't say forcible felony. It says any felony. We know that Mr. Reeves is 71 years old, and this great state of Florida protects the elderly. If someone commits a misdemeanor battery against Mr. Reeves, it automatically becomes a felony. So under these circumstances, Mr. Reeves did not even have to wait for him to be severely damaged under 782.002.
Isn't there a knowledge element to battery on an elderly person? Wouldn't he have had to know that he was over 65?
Well, Your Honor, unfortunately, the answer is no.
There is?
No, Your Honor, that's a very gray area in the law and has been heavily litigated in the past. But what we have to remember is how close was Mr. Olson from Mr. Reeves? Does he look like he's a day or 2 younger than 65? Let's assume that the court were to rule in that fashion. That's what's happening. That's what's happening. He is under the impression at that point in time that he is, at the very least, going to be battered. His own testimony was it was beyond a misdemeanor battery, that he was going to be seriously injured by this gentleman. Why? He had no means of protecting himself. He couldn't use his hands against a 43-year-old, 6'4", 200-pound individual. What did Vivian say? She was so scared she turned away. His wife right next to him. Elderly, health problems. Was he just assessing his situation? Was he assessing his situation and his wife's? Of course he was. 46 years married to this woman and loves her dearly. 776.012, which is the stand your ground. And it deals with the issue of, same thing, serious bodily injury or a forcible felony. And I will tell you that the district courts of appeal of this state have had some real problems with the definition of what is a forcible felony. And we have 2 Supreme Court cases that I believe the government cited. Actually, they cited one, but there was an earlier one that came about, where the Supreme Court tried to define what forcible felony was. And there was 2 long opinions dealing with, well, how do we do that? And do we do that strictly by an elements approach, or do we do that by the actual physical act that was taking place? I would suggest to the court that for a self-defense situation like we have here, it should be the actual act, because it's Mr. Reeves that's using that defense based upon his perceptions. They were applying that forcible felony rule in those two cases, dealing with the Prison Release Reoffender Act, where individuals get punished harsher if they qualify under certain offenses, and the I think it was the Violent Criminal Act, which, again, they get punished a bit more severe. So the context of those Supreme Court cases were such that they were not being necessarily applied to a self-defense issue, with the exception of the earlier case, and I'll have to pull that for the court, I've got it. It dealt with whether a trafficking in narcotics was a forcible felony. And the court said, not all traffickings are forcible. Some could be forcible, but you know we've got to go to this element approach, because I am sure that the court felt, how are we going to relitigate, you know, these particular cases and deal with the issue of whether it was forcible or whether it was not forcible. The court was clear in those opinions to say, you know what, if a battery is committed, and it's committed with any degree of force, yes, it could be a forcible felony on a battery of Leo. It could be a forcible felony on someone that's 65 years of age or older. But we're not willing to go there. We're going to define forcible felony by an elements approach, and that is it. I suspect there's going to be a great deal of litigation dealing with this issue in the future. Self-defense. His testimony that he gave immediately after this incident, recorded after someone read him his rights and said, Mr. Reeves, anything you say can be used against you in the future, is uncontroverted by any credible evidence. In fact, his testimony is corroborated by that type of evidence that we probably want to rely on more than anything. That's physical evidence. It's that physical evidence that doesn't have the ability to be persuaded by things in life that shouldn't really entertain someone's desires. I know that there was individuals in that theater that were heartbroken over what had happened. I know that Mr. Cummings, Mr. Friedhoff, Mr. Hamilton, Mr. Turner, they witnessed this. They tried their best to help Mr. Olson. And so there is a sense of wanting to help Mr. Olson, not only then, but thereafter as well. This was a dark theater. If we remember Mr. Friedhoff's testimony, let's think about this, because this one is very, very important. Mr. Friedhoff was about 3 rows up, and he was having to look over his right shoulder between his girlfriend, who was to his right. And he indicated, you know, I was looking back and, you know, I was able to see Mr. Olson's cell phone on his lap. Now think about it. These are high seats, and he's able to see Mr. Olson's cell phone on his lap. Well, what about Mr. Turner? Mr. Turner said, you know, when Mr. Reeves left, Mr. Olson stood up and he was standing up the whole time with his phone. Remember I asked, I said, what about Vivian behind him? Oh, you know, it was a preview, so, you know, he was just standing up with his phone, and yeah, I could see his light, and he's the scanner. He's the guy that scans wherever he goes, because that's his background. And that's what he was saying. Was Mr. Olson standing up like that? Was he waiting for Mr. Reeves to come back in order to attack him like he did? But one thing that Mr. Friedhoff said that was so important. Remember you know, I heard some crumbling of popcorn, but then I heard a thump. But then I heard a thump. Consistent? Of course it is. I listed in my memo many second DCA cases and a 4th DCA, Dorsey, that cited many second DCA cases, dealing with the issue of the overreaction of one that was claiming self-defense. Not one of those cases was addressed by the prosecution. And there's a clear answer to that. They couldn't. Those cases are rock solid. Those cases tell Your Honor that under these circumstances, at best, what they could do is maybe charge manslaughter. Not that they'd get a conviction, but that the factual basis in order to make that decision, at best, if that's their theory, supports a charge of manslaughter. They've proven not one scintilla of ill will, spite, hatred. In all those cases talked about, you can't develop those in a short period of time. I know Your Honor read those second district cases. I know Your Honor read the Dorsey case.
I did.
They were extremely on point. They were right on point. And the only cases that they actually cited were cases that were not dealing with self-defense. The only case that dealt with self-defense was a 1934 case that actually we adopt as our position. I'm sure the court remembers the 1934 case of, it was Ramsey. That was the one dealing with the father and the daughter and the gentleman that was disrespecting sexually his daughter.
Yes.
And the court in Ramsey talked about 3 different types of malice. And they said, you know, it may be some other crime, but it's not second-degree murder, because there was no evidence here of hatred, malice, the necessary elements that you need for second-degree murder. This could have been a response to an emotion that he had because of the disrespecting of the daughter. That was a case they cited. And it supports our position. The only case they cited that has any relevance whatsoever to the issue of self-defense.
Well, I'm going to be asking them about their cases on self-defense and their cases on second-degree murder in a minute, but one of the things I'm interested in for my decision, when I decide on proof evident presumption grade, when I decide on that, do I take into consideration the affirmative defenses, or do I merely take into consideration whether the state can in fact prove their case absent the affirmative defenses? Because the affirmative defense of self-defense has to be established by the defense. I would never put any proof requirement on you for the proof of guilt, but if you wish to establish an affirmative defense, that's on you. So when I analyze the state's case and ask myself, have they met this high standard? Should I be asking myself, have they met this high standard, and then has the defense rebutted it? Or should I simply be asking, have they met this high standard, and at trial then I will hear whether the defense has provided the affirmative defense?
Your Honor, I can answer that question, and with all due respect to the court, I disagree.
That I should even ask the question?
No, I disagree that the defense has the burden of proving self-defense. We have the burden to go forward with self-defense. They have to prove, beyond and to the exclusion of a reasonable doubt at trial, that it was not self-defense.
I probably phrased it poorly. What I mean is you have to establish self-defense, and then they have to knock it down. I recognize that. It's more just a, should I be looking at self-defense now, or should I be waiting to look at self-defense at trial for purposes of JOA and for purposes of instructing the jury?
You have to be looking, Your Honor, and I say this with all due respect to the court, you have to be looking at self-defense now. If not, those individuals that exercise their absolute legal right to self-defense would be kept out of the loop. Well, forget about it. If you assert self-defense, no one can consider it until we get to trial. That's not the intent of any law that I'm aware of in this great state.
Is there any case that tells me that?
Your Honor, I'm not sure that there is. I can tell the court I have not read that, but let's look at practicalities.
Well, I was looking for the cases before I was looking for practicalities. I go to practicalities when I don't have cases.
Your Honor, I'd love to be able to get you that case law if you'd like me to. I am sure that there's got to be some case out there that stands for the proposition that, no, you've got to look at all the evidence. And if there's evidence brought forth by the defendant that says, you know what, this is self-defense, and it is supported in any way, they've got to prove it not only beyond to the exclusion of reasonable doubt, but the case law is clear. Their burden is beyond to the exclusion of a reasonable doubt.
I know, I read that. I'm just trying to figure out if in my analysis I have to apply this self-defense now.
Absolutely. I think you do, Your Honor, and with 30 years of experience, I think that I am on solid ground there, because it would make no practical sense for the law to say, you know what, here at this stage, we're going to just leave you in jail. And the only time that the court or anyone can consider the issue of self-defense is when you go before a body of your peers in a jury. That would make no sense, and I seriously doubt that any court would rule in such a fashion. It's their burden from day one when they charge someone. It's their burden throughout the entire period, and it's their burden at trial.
Well, affirmative defenses, though, suggest they're affirmative defenses and they have to be raised by the defense.
I would agree with you if this was the case. If we had to prove beyond a reasonable doubt self-defense, I'd say, maybe there's an argument here. But that's not what the law says. The law says all we have to do is introduce some evidence of self-defense. And in a trial, it shifts right back to them, and now they have that ultimate burden of proof beyond and to the exclusion of a reasonable doubt.
Okay.
And here, it's even beyond that.
Well, that's why we're talking it through. I like to get both sides' input, and I'm going to get Mr. Garcia's input on that. How about this? Is the standard ground statute that place that you could go requesting the immunity of the court prior to going to a jury? Is that a mechanism that the legislature is now built in as your outlet prior to trial?
It has, Your Honor, and the beauty of both 782.02, which is not the stand your ground, and 776.012 is that the law doesn't say that the only time that you can use deadly force is if someone actually pulls out a gun. And so if they pull out a gun, you can pull out a gun, or if they pull out a knife, you can pull out a knife. That's not what the law says. The law doesn't even mention what that person has to do in order to create that fear. The only thing and the most important thing that the law does create is it says, you know what? If you're going to judge this gentleman on the issues of self-defense, you're going to be stepping in his shoes. And that reasonable person has got to say, okay, I'm a reasonable person, but I'm a reasonable person that's 71 years old. And I'm a reasonable person, but I'm a reasonable person that has arthritis in both hands. And I'm a reasonable person, but I'm a reasonable person that has arthritis in the bad back. And you know what? I'm a reasonable person, but I am sitting in a theater that it is dark, and this gentleman is coming over the back of the chair. That's what we have to do with the law of self-defense. It is not playing Monday morning quarterback. And the reason we don't play Monday morning quarterback under those circumstances is when you're looking at that Monday morning play, you have a better advantage. You may be looking at it from the cameras that are high up on the field. And so you're able to see what Tom Brady can't. That's not the law of self-defense. The law of self-defense here is we don't go to those cameras, we go to him. And we have to take him as an experienced 27-year veteran that has been highly trained to look at the dangerous factors that could result in his serious bodily injury, death, or, under 782, any felony.
Well, here's what it says in the transcript. It's not the transcript. Here's what it says as I sat and quietly and tried to write as quickly what he was saying when he was being talked to by Detective Proctor. He said, I couldn't take that ass whipping.
Exactly, but he also said, I thought I was going to be seriously injured, and I would beg the judge, listen to that audio again, because it's right there. It is right there. He says, I was concerned that I was going to have some serious injury.
I heard him say that too, but I also heard him in a reflective moment say that it was going to be an ass whipping. And ass whipping means a lot of different things to a lot of different people, I suppose, but an ass whipping to me just means get beaten up.
Well,
should I take it a different way?
An ass whipping to you may just be beating up. To me, it just may be beating up. To a 71-year-old man with these kinds of ailments, it could be his life. And that's why the Florida legislature has said, you know what? We've got to protect the elderly. They're far more frail than the 20-year-old or the 30-year-old or the 40-year-old. These individuals get a punch to the head and they die. These individuals get a punch and they fall and they break their hip and they die. 50% of the elderly people in this country that get a broken hip, they die. 50% is that high.
50% of people.
50% of the individuals, the elderly individuals, not the young individuals, the elderly individuals, they die.
Eventually we all die, but you're saying that approximately from a broken hip they
Well,
die?
it's all the complications that come with that, Your Honor.
Okay.
It's being in bed, it's the congestive heart failure that results in not being mobile, absolutely.
Okay.
And so the legislature has seen this. I didn't draft this law. The Florida legislature has said, you know what? We've got to protect the elderly. And so, yes, Your Honor, an ass whipping for a 71-year-old could be his life. If we were here and he had not pulled that gun and he had been hit and he had died, we'd all in this room be saying, Mr. Reeves, 27 years on the force, commander of the tactical squad, you had a weapon in your pocket and you didn't realize that your life was in danger? That's what we would be saying today. That's what we've said for many fallen officers in Hillsborough County. That Officer Roberts, who approached that homeless man, the homeless man with the cart, that nobody thought was dangerous.
You know, this is objectionable, okay? You can't, this apples and oranges, and it does disrespect Officer Roberts.
No, it's
All right, look, move on.
I will.
I get what you're saying, people are unpredictable.
Your Honor, I certainly think that with the family support that Mr. Reeves has in this community, with his history of being nothing but an incredible public servant, that he is not a danger to the community, he is not a risk of flight, he is going to have his day in court, but he needs to have this time outside of the Pasco County Jail so that he can assist his lawyers with this defense. The evidence that we've brought before you, Your Honor, creates incredible reasonable doubt. Incredible reasonable doubt. Not one of the state's witnesses really coincide with the other. And then if you listen to Ms. Olson's statement, she says, my husband didn't curse, my husband didn't hit anybody, my husband didn't do any of that. Please listen to her tape again. She says her husband didn't hit anybody, didn't strike anybody. The only thing he says, hey dude, what's up with you? Or what's wrong with you? And what do we see on the video? Just the opposite. Not one single witness that they presented before this court is credible. And not credible because they're bad people, Your Honor. They're credible because they witnessed an event that was very traumatizing. And I think that certainly in their heart they want to do everything that they can for Chad Olson. But fortunately, the facts of this case, the cell phone, spells out the video, the light, corroborates the statements of Curtis Reeves. I'd ask the court to consider pretrial release. Mr. Reeves is willing to abide by any conditions this court deems to be reasonable and prudent. And I respectfully ask the court to consider those and allow Mr. Reeves some form of pretrial release, monetary or not, until we're able to go to trial and prove his innocence.
On a break, man, it's gonna get pretty animated. How do you break? I'm gonna give my courtroom staff a break. It's not fair to go right into it. We've been going for quite some time, so we're gonna take you want 10 or 15? We're gonna take a 15-minute recess. We'll be back at 3:45 to continue.